Welcome back, everyone, to another compelling session in the Working Group on Theory seminar series of the cost action of K-Peritia. Blazej and I are thrilled to have you with us today as we continue our exploration of cultural expertise in the Middle East.
Absolutely, Dina. Our previous discussion on cultural expertise in the Middle East indeed emphasized the region's unique conceptual and contextual challenges. Today, we build on that foundation with a comparative perspective that further deepens our understanding of cultural expertise in the human rights context.
That's right. In a previous seminar, we examined the linguistic and cultural dimensions that shape the role of expertise in this region, highlighting how these factors influence legal and social applications. Today, Sahar Kahn provides a critical comparative analysis of cultural expertise in human rights frameworks, specifically focusing on the UAE and international standards.
One of the crucial intersections between today's seminar and our previous discussion on the Middle East is how cultural expertise navigates the relationship between the national and international human rights frameworks. Dina's work has set a stepping stone for an exploration of cultural expertise in the Middle East and highlighted the importance of regional specificity in understanding this theoretical pursuit. Sahar Khan's contribution expand on this by analyzing the normative and linguistic challenges in aligning local practices with global human rights standards.
Exactly, Blazej. Khan's discussion underscores the groundbreaking potential of cultural expertise in bridging these frameworks, offering insights into how cultural knowledge and linguistic choices inform legal interpretations, policy development, and advocacy. Her work also intersects with Livia Holden's exploration of ethical consideration in applying cultural expertise, reinforcing the need for context-sensitive approach.
Exactly. This session is a thought-provoking discussion on the evolving role of cultural expertise in culturally sensitive human rights applications. We look forward to engaging with you on your offered insights and deepening our collective understanding of these critical issues.
Thank you all for joining us. Without further ado, today's seminar is to your kind attention.
This topic, this conversation, it's not so much just about the formal implementation of disability law, of international disability law, international law. It's actually about realizing the emancipatory spirit of international human rights at the local and national level. And that's where I bring cultural expertise into the equation. I'm now going to go ahead and share my screen so that you can look at the PowerPoint slide rather than me. Okay. So you should be able to see the slides now. And my central thesis is that by and large, we cannot translate international legal precepts, universal human rights, and guarantees without some sort of cultural go-between, some sort of cultural broker, cultural mediator who would provide us insights on how international human rights might be realized in specific cultural contexts in a culturally sensitive and culturally effective manner for right holders. So the key, of course, here is right holders who belong to a cultural context. Disabled persons in the United Kingdom belong to a cultural context. Disabled persons in the UAE belong to a cultural context. So in order for the rights that have been enshrined in international law, for them to actually be invocable by them, for them to actually mean anything at the local level, we need these cultural mediators who can tell us how to translate those laws into local settings. So on the one hand, I approach this in a very interdisciplinary way, which makes sense because my own academic DNA is very interdisciplinary. My first discipline was history. My second was development economics. So I have done both a very quantitative work with econometric models and the R software. And I've also done highly qualitative work, taking oral testimonies and collecting oral histories. And so that's the approach I take to this. And now my third discipline is the law. And so on the other hand, what I'm trying to do as a lawyer is actually build a case, a legal case for cultural expertise, to present to my own fraternity, to go back to them and say, hey, folks, we need to understand as lawyers and legal scholars why cultural expertise is important for us. And the main principle that I use to do that is the principle of legal subsidiarity, which I shall explain in the second half of the presentation. But first, let's find out what food for thought our Global South disability law case study might have to offer to us. So this will actually enable us to get into the nitty-gritty of what it means for cultural expertise to have a role in this very important legal task of realizing distant, global, international, universal human rights aspirations in the actual real lived experiences at the local level of implementation and empowerment, and situating these within the case study actually helps us both theoretically and also practically. So theoretically, we actually get to test cultural expertise theory, which means that we can also further develop it. And one of the main theoretical insertions that this particular case study offers is the role of sociolinguistic experts. What do linguists have to say? Native speakers of Arabic, you know, in a region which Arabic is a language that covers such a huge region. So those types of experts coming into the conversation and influencing how laws are implemented, what kinds of laws are implemented. So that's the first thing that we're doing theoretically. And practically, we get insights on the role of cultural expertise, not just in the courtroom, but in developing a legal language for human rights. In particular, its role in legislative lawmaking and legal cultures. And this is a relatively new context because usually when we think of cultural expertise, at least when I think of cultural expertise as a courtroom lawyer, I think of courtroom experts. So we're bringing in someone to explain what a witness is saying because the judge may not be able to understand the cultural nuances. But what I'm suggesting is that there is a huge role for cultural expertise in legislative lawmaking, in developing legal languages and legal cultures, especially around human rights, because human rights is experienced locally in lived experiences by people who belong to cultural contexts. And I've been browsing the cultural expertise book, and a lot of meaningful work has been done on cultural expertise and various human rights, such as indigenous rights, refugee rights, LGBTQ. And I think disability law and disability rights, it presents a brand new context for us to hunker down and really understand how cultural expertise will work in this context. And here I've given sort of an umbrella concept of cultural expertise and cultural experts. And I've actually highlighted sociolinguists and psychologists. We also have native language speakers and translators, legal professionals, cultural mediators, academicians, country experts. But this case study probably will highlight most the sociolinguistic aspect. And so with that, we come to the structure of my presentation. So to really understand the relationship between cultural expertise as a sociolinguistic phenomenon that relates to right holders of empowerment, I cover three main levels of analysis. The first being national, and that will cover national UAE case study. The second being international, which looks at international law generally and also international disability law specifically. And the third will be a sort of horizontal level of comparative law, where we actually compare the UAE formulation with the Anglophone, Western, global North countries, and also the Francophone formulation. That we come to our case study. So the United Arab Emirates is a party to the UNCRPD, which is the United Nations Convention on the Rights of Persons with Disabilities. And the UAE shifted its legislative language from disability, al-ashkhas, dhawi al-iqa, to persons or people of determination, which is ashab al-himam. In 2017, this change came about. This change came as part of the mission to make the UAE a more inclusive society that preserves culture, heritage, and traditions. Plainly put, the word disability is viewed in workplaces and schools as signifying that persons with disabilities have an incapacity. They can't do something, they're not capable. And regrettably, that has become a social stigma. And these are conversations that you can only get from speaking to Emirati students, Emirati scholars, just Emirati citizens in general, to really understand the social stigma associated with persons of disability within their society. And this has created problems in employment as well, leading to people viewing them as employees and members of societies who are unable to contribute. I went ahead and I spoke to two Emirati scholars in particular. I spoke to Manal Muhammad al-Marzouki, who's an Arabic language expert, and she did her PhD in sociolinguistics. She was also giving me contacts to people who did their PhDs in legal linguists. So we still have much of a way to go to learn more about this. We also spoke to an Emirati legal scholar about this. And one of the things that our linguist highlighted and took care to explain was the word himam, which has connotations of courage, determination, and inspiration. It even conjures the ability, capacity, and capability to do something. It is the pluralized version of himma, which is the singular for the same notions. She also brought to our attention the choice of the word ashab, which is people, but it's also like companion and friend, as opposed to just nas or al-ashkhas. So there are many things that we can go to in terms of the minutiae and the particularity of this, but we are not linguistic experts, so I won't go into that much detail with that, but I do want to give you a flavor of what it means for cultural expertise to play an important role in this sphere of law. We also explained to her, Professor Jinan Bastaki and I both explained to her the UNCRPD. We told her the positive law. We told her the spirit of the law, and she suggested that something is lost in translation when we transpose the Western English language version directly into Arabic. She suggested that it translates the literal meaning, creating an awkward phrase in Arabic which does not possess the emancipatory weight behind the law. And in a way, we can also ask, would it be so difficult to imagine a metaphor? Does the LGBTQ community not utilize the terminology of pride? And of course, that's not a legal label. But what these metaphors do is that they empower and they change one's self-perception. They also change the perception of society. And we're actually really talking about law in action. We're talking about law in society as a theme. Law is not just words on a piece of paper in a fancy treaty. It is something that is to be implemented, that is to empower the end users, as they say in tech, or right holders, as we say in the legal world. Interestingly, there was a term that preceded al-ashkhas dhawi al-iqa, which was mu'aq. And mu'aq is a term possibly closer to handicap, which is considered worse than the new term, which is persons with disability. And even the UNCRPD iqa has its roots in mu'aq, which might explain why a third terminology, ashab al-himam, was sought beyond the iqa supposedly inherited from the UNCRPD. And so it's not easy for me to sit here and pin down exactly what is happening here. However, could it be that the UNCRPD language was an improvement upon the initial local label, and the latest determination language was meant to be an improvement upon the supposed UNCRPD formulation? And what could be interesting is, if the national plains and international hills are in conversation with each other rather than a competition, what we see is one is evolving and pushing the other to become better in the interest of and for the betterment of the ultimate right holder, or what we call, as I said, end user in the tech world, which is more popular these days than the law, unfortunately. This is informed conjecture at this stage. We have to go on and verify and validate these hypotheses. But Emirati and Arabic linguistics expertise is being sought to clarify the minutiae of this linguistic legal subsidiarity. Professor Jinan Bastaki took care to actually highlight something about mu'aq. And she said that growing up, she gave a very personal anecdotal view on it. And she said, growing up, it was not a positive word because it signifies and is perceived to signify the inability to do something. And she said this could be interpreted as the inability to join schools, workplaces, public life. She also said that because iqa has the same root as mu'aq, it has a similar connotation. And so in her opinion, this new terminologies signal something new to society and also to the individuals who themselves are persons with disabilities. One thing that it was very interesting, Professor Marzuki highlighted, was that the logo has also changed. So with this change in legal language, legal culture, the visual justice, the visual thinking around this is also changing. This logo shows a disabled person in motion. And if you look at other disability logos, it's just someone holding the wheelchair. She considered that to be positive. We, of course, have to consult other linguists, other professionals, other cultural experts to ensure objectivity. And most importantly, we have to speak to the persons of determination. What do they think about this? The other thing that was highlighted by Professor Jinan Bastaki was legal pluralism. And it was the retention of old and new terms while discarding mu'aq. So they said that in the United Arab Emirates, persons of determination is used, but also persons with disabilities, so as to be understood regionally and internationally, and special needs in certain contexts. However, they both took care to emphasize that determination terminology is preferred and that is also encouraged to be adopted as a positive social metaphor, but they still want to be understood by the international world, by the regional sort of comparator language. And that doesn't mean discarding altogether the international legal language. It's just saying that we're going to use this in a context-dependent manner so that persons with disabilities in the United Arab Emirates don't face the brunt of social stigmas. Here you can see that there is a sort of layered relationship between international law and national law. And it is arguable that people of determination is not necessarily a departure from international law, rather it is a culturally appropriate implementation of international law. And this new language has actually created, as you can see here, people of determination services. It's created an entire legal and policy infrastructure around which right holders, services, and rights are now organized. So far, I have explained why, from the national perspective, it would be desirable to have a new formulation. And now I want to consider the international law perspective. So here you can see, I'm proposing that there's a gap between what international law should be and what international law is. And I'm also asking the question, is international law truly international? So, international law is meant to serve a culturally and economically diverse international community that consists of the global north and global south countries. Yet the reality is that its legal concepts, its languages are mostly, if not entirely, born from global north heritage and history. So does it continue from that level of internationalism to the local level of implementation that the objectives of justice are actually realized? Possibly not. The other thing is that international human rights are taken to be universal, and they very well should be. I'm in favor of the universalism of international human rights. However, the problem is that these universal human rights were almost exclusively conceptualized in global north intellectual and cultural contexts, not global south contexts. So we now have to do the work with cultural experts to think about how we're going to rectify, how we're going to make good for this gap that exists in international law. If international law was truly perfectly universal and international, we would not have to worry about implementation and transposition in a culturally effective way. We would not have to correct at the national level through legal subsidiarity and cultural expertise. The gap, of course, poses a huge problem, and it is difficult, if not impossible, to tackle the entire gap by considering the totality of international law. That is why I look at a more microcosmic study. I look at international disability law to sort of situate culturality and the challenges of cultural relativism to universalism. So I've already mentioned that the UAE is a party to the United Nations Convention on the CRPD, and so are lots of others in terms of global South participation in these treaties that have very little to do with their own histories, heritage, juridical lineage. And it's not clear that multicultural or multi-jurisdictional, multilingual surveys have been done in the drafting of the UNCRPD or any treaties, actually. If you go and read about, many scholars have done work on whether or not international law is truly international. And one of the main arguments that are levied against the drafting is that we've not really done surveys, but we have lots of different cultures signing on to these treaties. And so that poses an issue. Most likely what scholars think, and you can go and actually look at the archives in which we record how these treaties are drafted, more likely than not, the language in these treaties is drawn wholesale from Anglophone and Francophone juridical linguistic heritage, which we should be asking questions about this. There is nothing wrong with this per se theoretically, but as I said, laws are not just words. They have to be implemented for Emiratis as much as Americans, as much as Pakistanis, as much as Colombians. So those histories, those cultures need to be taken into consideration. And one of the things that cultural expertise can help us answer in the disability law context is whether in a specific cultural context we go for a strength-based definition of disability, such as persons of determination, or we go for a deficiency-based formulation, which is persons with disability. And these are debates that we have in the area of disability law, and no one stands anywhere really, because people make lots of good arguments in favor of one or the other. But the reality is that these are empirically determined questions. These are questions whose answers lie at the ground level, in the cultures, in the lived experiences of the right holder. So that's one of the things that culturality can really help us answer, is to go and ask people on the ground, the right holders, the cultural experts, the lawyers, what is the appropriate formulation in this society for disability law? And then another debate in disability law is whether we have person first formulation or identity first. So person first formulation is persons with disability. And identity first is disabled persons. So the UAE's new formulation is a person first formulation, which suggests that one is a human being first and foremost, and then with an identity, as opposed to being entirely defined by their identity as disabled persons. Again, we don't know at an objective normative level what the true answer to this is. We need the culturality, we need the subjectivity at the ground level. We need to conduct studies, empirical studies, to understand what is appropriate in a specific cultural context. And to summarize, we must ask ourselves whether international law universally empowers everyone. I have suggested that it doesn't, due to the gap. And there are others that you can read about, in particular the scholars that work on whether or not international law is international, who provide ample evidence in favor of this argument. And then the question becomes, how can cultural expertise help bridge the gap between what the international law is as it stands today and what it should be? And that's where I come in to try and build the case for the legal case for cultural expertise, which lies in subsidiarity. So with respect to subsidiarity, I invite you to consider that the whole idea of implementing laws in a culturally appropriate way It shares in the epistemic heritage of a jurisprudential principle in international, transnational, and national law called legal subsidiarity. Now, what is this principle? In the social sciences, subsidiarity is a principle of social organization that holds that social and political issues should be dealt with at the most immediate or local level that is consistent with their resolution. At the legal level, this means that laws should be implemented in a manner closest to the local level at which they are implemented, while also involving all those whom it affects. This means that international law can tell the national actors what the law is, but the national actors determine the how of implementation with the collaboration of cultural experts and cultural expertise as a broader notion as well. And that is what will enable, we argue, universal rights and the spirit of justice behind those universal rights to be realized at the local level and in a specific cultural context. And this is the principle that I hang cultural expertise on as a lawyer. And this is the principle that I take to my own fraternity to convince them that we need to start working more with cultural experts, especially in international law, especially in public law, and any sort of human interest law. So as we bring the international section to a close, I would like to highlight the normative and empirical questions that remain for us. So there's a connection between legal language and culture at the normative level. I've already addressed, is international law truly international? Already have looked at cultural effective and sensitive implementation, the role of cultural experts as linguists. Should legislators and lawmakers have cultural training? I think that's a really important one that I've so far not highlighted as much, but that is a role for cultural expertise as well, a very important one. And at the empirical level, we need to actually ask, does cultural expertise in legal language enhance rights for right holders? Does it elevate their status in society at the community level? So now I come to comparative. I know I'm running a little bit short, but I'm going to try to get through comparative because this is quite important as well. Here you can see we have an image here. I found this very fascinating. This is an image of a tweet from the US mission to the UAE, suggesting that this diplomatic mission supports the determination formula. Now, in reality, many US and UK Anglophone legal scholars take issue with the new determination formula, and that's because it doesn't work in their context, because these are culturally specific labels. And allow me to explain why. Disability terminology is considered sort of a legal fixture of the Western social inclusion model. And of course, we must ask, is it really international? In the Western Academy, it's actually not possible to question the disability terminology. And persons with disability who push for alternative formulations risk being labeled as self-hating persons with internalized ableism, who cannot tolerate viewing themselves as disabled. And so, like other universal human rights, disability rights acquires a universally incontestable veneer. However, there are very good arguments in a global North context not to change this terminology. And I respect also that terminology. And in the global North and in the Western context, perhaps we must steadfastly protect disability rights within the formulation of disability rather than determination, because of the danger of losing hard-won rights that came out of the history of disability advocacy in the global North. Many global North disability advocates rightly argue, on the basis of their own context, that one must acknowledge what is lacked to give people their reasonable adjustments and rights. And that's why they argue in favor of a deficiency-based formulation. This is because actual rights protection flows from legal language. Now, having said that, on the other hand, since that argument is based on disability advocacy in the global North, it does not necessarily flow from global South disability legal histories. Other than this, in as much as we value the above mentioned arguments made in defense of the disability formulation, what about considering how disability defines persons in terms of what they lack vis-a-vis able-bodied persons? Could we imagine referring to Black people as non-white? So there are questions that can be asked about this in a respectful manner, in an empirical manner, respecting objectivity and cultures. And that's really where the cultural experts need to help us as lawyers to understand and navigate what is a culturally sensitive area of law. And then we have to ask, should we be grafting and transplanting concepts from global North historical contexts onto countries which do not share the same legal history? So my point as a legal scholar is that I have a strong interest in cultural expertise, not to favor one culture over another, but because cultural experts help me understand what is the best formulation for right holders. And I just want to cover this important little piece before I move on. I just want to take the example of one more language, that is the French language. So some might take issue with the French terminology, which is les personnes handicapées, and that basically uses handicap. The English terminology has moved away from handicap to disability. This is considered gauche in the Anglophone world now. It's considered old-fashioned and regressive. And the fact that this turn of phrase persists in the Francophonie is surprising, given that French language theoretical disability studies is actually very refined. It's very sophisticated, and it does take cultural into account. It does take cultural expertise into account. However, that has not been translated into legal human rights. That perhaps goes to show that there is a divide between theory and practice, and that can be bridged for the better. And we need the cultural experts for that. Of course, it is unclear if this is a task for the legislators or the linguists at Académie Française, or both, or work together with cultural experts from not just France, but the Francophonie at large, from the Arab Francophonie, from the African Francophonie, to really understand what works and what doesn't. So I do have a lot more to say, but I also want to open up for discussion. And I think the main takeaway, if there was any, it's that lawyers need cultural experts to clarify the minutiae of linguistic legal subsidiarity.